The next case is In Re AP. Each party will have 15 minutes to present the argument. The appellant, you may reserve up to 5 minutes for rebuttal. How long would you like to reserve?
3 minutes.
Thank you. I'll be keeping time up here, so there's no way for you to see the time, so I'll try to let you know there's about a minute left in your time. I may not need rebuttal since it's a shorter period of time, but certainly in the initial time, I'll let you know when you're about a minute, and I'll let you know when you're about a minute left in your time, counsel as well. The arguments are being recorded, so when you come up, please first introduce yourself. Secondly, if you stay behind the podium, because we're visually and audio recording you so we can see you, and stay there so we can hear you as well on the recording. As you've done in this case, when you use the name of a child or a minor, please make sure you use the initials like you've done in this matter so far. We read your brief and are ready to proceed whenever you are.
Good morning, Your Honors. May it please the Court. My name is Jamie Salazar with the Ohio Public Defender, and I'm appearing on behalf of minor appellate AP. The Ohio Supreme Court has made clear that a juvenile held in a secure facility on 2 separate and overlapping cases is entitled to credit for time at that facility in connection with a probation violation complaint, so long as it relates to the original delinquency complaint upon which the DYS order of commitment is based. In this case, AP was repeatedly ordered by the juvenile court to remain at the residential treatment facility Hill House pursuant to the original delinquency complaint, the 2020 complaint, upon which his current DYS commitment is based. And therefore, he is entitled to an additional 760 days of confinement credit for the time spent confined at Hill House. The juvenile court in this case erred when it denied AP's motion to recalculate the confinement credit. Therefore, we are asking that this court correct the record to add 760 days, or in the alternative, remand it back to the juvenile court for proper recalculation pursuant to RC 2152.18b. A juvenile is entitled to receive credit for time served in confinement in connection with the delinquent child complaint upon which the DYS commitment is based.
Do we have anything in the record about Hill House being a confinement facility? The way it's captured in the briefs is that it's inpatient mental health treatment.
It is a residential treatment facility, and in our original motion, we laid out the arguments for why it is a secure facility. And the evidence for that. However, the state did not object to that, and the juvenile court did not address that in its denial either. So for all purposes in this argument, it is a secure facility.
Do we have any analogous adult criminal cases where the court says that a mental health facility that's residential is confinement?
I don't have that for you today, just because it's not an issue in this case of whether or not it's a secure facility, but rather whether or not it counts for calculation credit. The judge in juvenile court denied the motion, not because it wasn't a secure facility, but because the juvenile court believed that it wasn't in connection with and wasn't extended by the current 2020 case.
So the order that he was sentenced, the disposition sentence says to continue mental health treatment, but it doesn't say anything about Hill House.
So it is specifically and expressly written to remain at Hill House in order to stay at Hill House. Yes.
In the case we're here for today, not
Yes.
the first case.
Yes, first, in pending disposition, when the original complaint is filed, the judge orders him to stay there. Again, when the actual disposition is adjudicated, he's ordered to remain there. And then in the probation violation, where he's committed to DYS, they recount that he was ordered to Hill House as well. So they expressly say that in the written injuries. So he remained at Hill House for 760 days until he was removed to another facility in November. It was at this new facility where AP received his probation violation and was committed to DYS the offense for which he's currently in DYS for. AP's time spent at Hill House cannot be credited towards the 2019 GSI case because it was dismissed, it was terminated as unsuccessful, and he was never committed to DYS on that case. So therefore, to credit that time to that first case would constitute issues of equal protection and equal dead time. Question, I'm sorry.
Did you argue that at the trial court?
I'm
The
sorry.
equal protection argument that you're making now, did you argue at the trial court that it could not be credited to the first case and only this case?
Yes, both in our motion for recalculation and then in our brief, that it can't be to the 2019 case because that would equal dead time, an unlawful result of equal protection concerns as stated in State v. Gregory.
Did
So-
the trial court credit it to that time, or did the trial court, just as you said, they didn't make a specific ruling on that?
Yeah, so the 2019 case was terminated as unsuccessful, so that those credits kind of just disappeared at that point because you cannot credit it to a case that no longer exists, and he's in DYS for the 2020 case. So in the alternative, if the juvenile court did want within their discretion to credit that time to the first case, what they could have done, which we've seen done time and time again, is commit him to DYS on both cases. Because both cases were active when the probation violation happened and when he was committed. But instead, the juvenile court decided to terminate the first case and then commit him on the second one. So therefore, that time he spent, specifically ordered by the juvenile court in the 2020 case to remain at Hiddle House, should be credited to that case. So for these reasons, and because the juvenile court erred in its calculation, we ask that this court correct the record.
Let me ask you then, before you get your conclusion, counsel, excuse me. You refer to Ohio Supreme Court states that it's required to give the time, in essence, and I assume you're citing to DS?
Yes.
But isn't DS somewhat different? In that case, it seems to me there was one course of conduct, that the youth was charged with an offense, that went up to the adult court, and then came back to the juvenile court. And the juvenile court's initial decision in that case was, this is a whole new complaint that was filed, so it doesn't involve this. This is the same, that's different here, it's different in this case. This was all in DS, the same course of conduct. Here's a different course of conduct. There's a 2019 offense where he was committed to Hill House. And then there's this new case where it's unclear, to some extent, exactly what was happening. Certainly, I think you're correct in citing there's language in the new case that he was being continued in Hiddle House, or I think that was the type of language used, not remanded. There was no distinction in the court order saying he's being committed to Hiddle House under case number 2019, blah, blah, blah. He's being committed under this case. That's somewhat unclear from the record. And the court had to make that determination as whether this was confinement connected to this case, in essence. So if you would touch this, I don't think DS is exactly the same.
So in DS, the court clarifies what the phrase related to the original delinquency complaint means, and they clarify that means that it's sufficiently linked. And so DS it's the exact kind of reverse engineering that DS was trying to correct, that you can't go back and then decide which case gets the confinement credit. It has to relate back to the original complaint in which the commitment was based. So in this,
in the original complaint here, theoretically, it's based on the 2019. He was first sent to Hiddle House under 2019, not the 2020 case.
he was originally first sent to Hiddle House on the 2019 case, but his time there was extended and ordered by the juvenile court in the 2020 case. So if he would have left Hiddle House or violated the rules.
Well, we're left to some extent interpreting what the language of the 2020 orders are when it said continued in Hiddle House, on whether that was being ordered in 2020 as a term of probation, or was that somehow just referencing 2019? Is that there's nothing explicit in your view of the 2020 case where he says, yes, I am, or no, I'm not, just to include this as part of the 2019 case?
I believe, if I'm understanding your question correctly, Your Honor, the disposition, the order was the juvenile is to continue residential treatment at Hiddle House. The juvenile is to make progress in and follow all recommendations. The juvenile is to obey the rules of Hiddle House and JFS case plan. So it was expressly ordered by the juvenile court that he be at Hiddle House, even if it was continued. The court in DS explains that you can be held on two separate and overlapping cases, but when it comes to the confinement credit, only the case in which he's committed to DYS matters, because that's the only case in which he can receive that credit. If we were to reverse engineer the same kind of thing that DS was trying to avoid, then that would become dead time. If you afford that credit to the 2019 case that no longer exists. It's almost like he was never held on the 2020 case in Hiddle House when the written entries by the court expressly keep him there. So because of that.
So are you saying that the 2019 case was dismissed at that point?
It was terminated as unsuccessful.
That's what I'm saying. So it was terminated as unsuccessful prior to the court in the 2020 case saying continue at Hiddle House?
No, Your Honor. So
That's
it
what I
was,
wanna make sure.
yeah, so these cases are both going on at the same time. They're
Okay, I
overlapping.
just wanted to make sure. Mhm.
And in both cases, he's being held at Hiddle House, expressly written in the orders. And then when he has his probation violation and he's committed to DYS, he's only committed on the 2020 case, and the 2019 case is then terminated.
How is this different than if you had an adult situation where the judge just sees the defendant in front of him and said, you know, we'll set this down for blah, blah, blah. In the interim, he's continuing at the Summit County Jail where he already was to begin with on another case.
Counsel, you have one, I'm sorry, you have 1 minute left, counsel.
Thank you. So I don't think it would be different in that he would still get credit for the time spent, is my understanding. And in this case, because the court, if the juvenile would have left Hiddle House, he would have been vulnerable to a probation violation in the 2020 case. So he's being held there in the secure facility as ordered by the court in that case. So when he's committed to DYS, it's that case that becomes important, and it's that case that where that time becomes dead if it's not credited to the 2020
I'm
case.
still stuck on the confinement issue. It sounds like Hiddle House, I don't know much about Hiddle House because I have to look at the record, I don't know if it's in the record, but it sounds like it's a private facility utilized by the court.
So
And so when we're talking about confinement, we're talking about you're not free to leave. I mean, how do I know he doesn't have passes out? Like in an Oriana House facility, it's not considered confinement if you're in work release. So don't I need to know more about this facility on the record before I can decide whether it was appropriately credited as confinement?
in this case, that was not an issue that was brought up by the state or the judge, so I believe it was waived as far as this appeal. But if you were to send it back to the juvenile court and they were to have an issue with whether or not it's a secure facility, we laid out that argument in our motion and provided documentation from the facility where they talk about that they are 24/7 watch, they're not free to come and go as they wish, and if they are to leave, they are immediately notified the police department, the sheriff department, and they would be vulnerable to a probation violation, making it a secure facility under the Napier standard.
Thank you. You're into your rebuttal time, counsel.
May it please the court, my name is Stephanie Zaranek, and I'm from the Medina County Prosecutor's Office, representing the appellee in the state of Ohio. The juvenile court was correct to deny AP's motion for recalculation of confinement credit. The important statutory language in this case is from Revised Code Section 2152.18b, which states in part that the court shall state in the order of commitment the total number of days that the child has been confined in connection with the delinquent child complaint upon which the order of commitment is based. AP seeks confinement credit for a period of time spent at Hill House that was not in connection with the complaint upon which the order of commitment was actually based. AP argues that this case is similar to In re DS from the Supreme Court of Ohio. However, In re DS only involved one incident, which, as Judge Stevenson noted, was charged once in the juvenile court and once on remand for the common pleas court. The fact pattern where one incident leads to one case is also true for the cases dealt with in Ray Thomas from the Supreme Court of Ohio in 2003. In Ray Thomas was a consolidated case with two separate juvenile offenders. Each of those offenders were adjudicated delinquent for one incident and were committed to the Department of Youth Services only after multiple probation violations stemming from that one case. Here, AP had two separate incidents, two separate complaints, and two separate cases. This case is more similar to In re OH out of the 4th District in 2010. OH had two cases, one in 2006 and one in 2008. When OH violated probation in his first case and was committed to DYS, the court gave him credit for days in detention for the first case, but not days in detention for the second case. The 4th District reasoned that the second case was a separate criminal offense from the first case, with the possibility of a separate sentence than the first case, instead of solely a probation violation in the first case. The Supreme Court of Ohio noted in DS that the analysis in OH was correct because the second case was not just a probation violation in the first case. The Supreme Court distinguished OH and DS, but again, DS and the cases in Thomas all dealt with one incident rather than two.
The question we don't know about OH from reading OH is, was there similar language in OH to the language in our case where in the second case they were indicating something along the lines of you are continued in Hiddle House, you are continued in this confinement in OH. We don't know if that exists. We know it exists here, so we have a specific language to deal with in the trial court of this is be continued in Hiddle House, and is that confinement connected to this case becomes a question.
Yes.
I don't know that OH answered that for us clearly, or
No.
DS or anything else does.
No, I believe that OH answered the question of how to deal with two of the cases dealing from two separate complaints. I'm not sure, as you said, how the analysis in OH actually played out in regards to the actual words that were in the judgment entries in that case. But in this case, we do have the language that that AP was being held in Hiddle House.
And speaking of Hiddle House, just to Judge Lansinger's question, do you at this time, do you concede, because there's no argument on the point in your brief, do you concede this was confinement, is defined under the statute, or that's something that if we were to overrule the trial court decision, we'd have to remand back and say trial court make a determination on whether or not Hiddle House was confinement under the statute?
I believe that you would have to remand it back to the juvenile court to make that determination. There's simply not enough information in the record about Hiddle House and its policies.
Was that something you argued below, that it didn't constitute incarceration?
I don't believe we did, Your Honor.
Because if you substituted the word detention center with Hiddle House everywhere, did the juvenile get credit for detention? Detention center time? I mean, if we're saying Hiddle House is equivalent to detention in this case. You see what I'm saying?
I see what you're saying, Your Honor. That's a good question that I'm not entirely sure how to answer. I think it would still be separate because of the separate case,
Okay.
but I'm not totally sure how to answer that. AP could not be ordered to Hiddle House as a new action in the second case since he was already there, hence the language in the journal entries regarding continuing his treatment at Hiddle House. AP had not been released from Hiddle House on his first case before proceedings began in his second case. AP argues that crediting the Hiddle House time from October 30th, 2020 to November 29, 2022 into his first case creates the problem of dead time, and cites State v. Gregory from the 1st District in 1995 from that proposition. In Gregory, the defendant was an adult, not a juvenile, which necessitates analysis under a different statute. Gregory was also a unique case in that the defendant was incarcerated for two different charges, was convicted of one, but eventually acquitted of the other. The 1st District noted that Gregory was being held pursuant to both charges, but only one of the charges, the probation violation in his first case, arose out of the offense for which he was convicted and sentenced. Therefore, the jail time credit was for his first case. Here, AP was adjudicated delinquent on both of his cases. None of the time AP served was dead time, as he still would have been placed in Hill House under his first case, even if he had not acquired a second case. Therefore, the state of Ohio would respectfully ask this court to uphold the order of the juvenile court denying a recalculation of confinement credit. Thank you.
The only relevant question here today before the court is whether AP's confinement at Hiddle House is sufficiently linked to the 2020 case. And it is. By looking at the written entries by the juvenile court that ordered him to remain at Hiddle House, not only prior to his disposition in the 2020 case, but also as part of his disposition, and then is referred to back for one of the reasons why in his probation violation he's being committed to DYS. The 2019 case that was terminated as unsuccessful cannot get that credited time as it does turn into dead space. Whether or not the Hiddle House is a secure facility is not a question before the court today because the juvenile court did not make a ruling on that. And if the court would like to make a ruling on that today, they can refer to our exhibit in the motion that lays out from Hiddle House why it is a secure facility.
Talking about just the dead time argument,
Of course.
it would seem to me if there was no language at all about Hiddle House in the 2020 case, was never ordered there in any way, shape, or form, the dead time issue would come into play. It would just sentenced to Hiddle House or ordered to Hiddle House, disposed into Hiddle House as part of the 2019 case, never mentioned 2020, we wouldn't have to talk about the dead time. The only concern here is whether or not it is or is not linked to the 2020 case. Is that fair?
Correct. In this case, the court very expressly has him stay there in his orders. So therefore, it's sufficiently linked to the 2020 case. And at this point, the statute gives all the discretion to juvenile court on how they dispose of the case and the adjudication that they give.
Should we defer it all to the trial court's own ruling, in that sense interpreting the 2020 order and saying, look, in this case, I wasn't ordered him to Hiddle House in 2020, it was only 2019, so I'm not giving him credit. Should we defer to that ruling at all?
No, so the juvenile court has all the discretion in its adjudication, but once that adjudication is made, the calculation of a credit is outside of the court's discretion at that point, and it simply becomes a calculation of where he was spent at the secure facility in connection with that case. And the statute makes that clear that as long as it relates back to the complaint on which he's committed, that he's entitled to that credit. The Ohio legislator has the language available to them to be able to specify a case. They could have said relates to the case number, and the juvenile court could have committed him on both cases, giving the 2019 time, but instead committed it on the 2020 where he was ordered to stay in Hiddle House.
I'll note you're into your rebuttal time now, if you would briefly conclude.
Absolutely. So for these reasons, the juvenile court erred in that calculation, and we ask that this court correct that record to add the 760 days to his confinement credit, or in the alternative, if they believe there's still an issue on whether or not it's a secure facility, remand that back to answer that question. Thank you, Your Honor.
Thank you, and thank both of you on behalf of your presentation today on behalf of the court. The court will take the matter under advisement and will issue a decision in due course. The clerk will mail a copy of that to you when it's released, and also be available on the High Supreme Court website. With that, the court is now adjourned until Thursday,